Hello students, greetings of the day. Today we are going to discuss the sources and schools of Muslim law, and the scheme of discussion is as under. We will start with the introduction, then the periodical development of Islam from 622 AD to present day, then we will discuss Islamic schools and their subdivisions, then we will discuss sources of Islamic law followed by conclusion. Now let's start the introduction. The birthplace of Islam was Arabia, a barren desert with extensive dunes and scorching heat. The Arabs lived in nomadic groups called Bedouins, led by elected chiefs called caliphs or khalifas. Before the arrival of Islam, irrational and cruel practices dominated Arabian society, such as gambling, slavery, and treating women as mere objects. Prophet Muhammad was born in Mecca in 571 AD, and his father Abdullah and mother Amina were killed at 6 years old. At 13, he began a business venture and married an affluent widow, Khadija. He had 2 sons and 4 daughters, but only Fatima, his daughter, outlived him. In 609 AD, during meditation, he heard an unfamiliar voice, Gabriel, invoking the name of Allah, commonly referred to as Wahi. The formation of Muslim law can be attributed to a series of political and administrative advancements within Arabian civilization, with the historical progression of Muslim law categorized into 5 distinct periods. Now, we will discuss the periodical development of Islam from 622 AD to the present day. The first is the initial era of the Prophet from 622 to 632 AD. This period was referred to as the legislative period. Initially, Prophet Muhammad's primary objective in Mecca was to instill a belief in the existence of God among the people. In the year 622, he embarked on a journey to Medina, where the revelations already revealed in Mecca were readily accepted, and he believed in the transformative events taking place in Medina. The Prophet typically establishes guidelines for regulating people's behavior. A revolution had occurred that successfully addressed all societal issues. Most legislative revolutions occurred between 622 AD and the sedition of the Prophet in 632 AD. Next is the periods of Khalifa from 632 to 661 AD. This period is called the inaugural era for the Khalifas of Islam. Throughout his lifetime, Prophet Muhammad possessed complete authority in means of law and religion. He served as both the spiritual and administrative leader of the Muslim state. Following his demise, an inquiry emerged over the individual who should assume the role of the successor to the Prophet. Most individuals concurred that an election should be conducted to determine his successor. Consequently, an election was organized and Abu Bakr was chosen as the successor. Abu Bakr assumed the role of the first Khalifa and gained a following among the Muslim population. Aisha Begum's father, the youngest wife of the Prophet, Abu Bakr, was highly esteemed among the Muslims of Arabia. Abu Bakr passed away in 634 AD. Following his death, Umar was chosen as the second Khalifa. Umar held this position for 10 years until he was assassinated in 654 AD. Following him, Ali, the husband of the Prophet's daughter Fatima, was chosen and became the fourth Khalifa. Ali was also assassinated in 661 AD. The first 4 Khalifas are referred to as the rightly guided Khalifas because they had the honor of being highly close companions of the Prophet. Now students, we will discuss the third period from 661 to 900 AD. During the early medieval era, this period flourished. Ali, the fourth and the final rightly guided Khalifa, had two sons named Hassan and Hussein. Following Ali's death, Hassan was appointed Khalifa. However, Hassan, a saintly figure, preferred not to engage in the administrative affairs. He willingly stepped down in support of Muawiyah from Umayyad family, who then assumed the position of the next ruler in the Muslim dynasty. Now students, we will discuss establishment of subsects, the fourth era from 900 to 1924 AD. The fourth period spans from 900 to 1924 AD. This era in Islamic legal history commences with the creation of the four schools and concludes in 1924 AD. The Abbasidis governed for 5 centuries until they were ousted by the Mongols in 1258 AD. Following this, the Sunni community experienced a period without a Khalifa until Abdul Qasim Ahmad was appointed as a Khalifa in 1261 AD with his capital in Cairo. The dynasty has maintained its position of power for over 2 centuries. Students, an essential characteristics of this dynasty was that the Khalifa lacked administrative authority at the start of the 16th century. Nevertheless, the Ottoman ruler Selim I received an invitation to join the group. This transfer of power from Khalifa to Salim was executed through a deed of assignment in 1571 AD. Following this, the Sultanate of Turkey was destroyed by Mustafa Kemal I in 1922 and Caliphate was permanently abolished in 1924 AD by the National Assembly in Ankara. Now students, we will discuss the fifth phase, which is from 1924 AD to the present day. Students, the contemporary era of Islamic law commenced with the abolition of Caliphate in 1924 AD. This phase has persisted since 1924. The individual lacked the qualifications to administer and carry out the rituals of Islam. This dilemma has been addressed by conceptually distinguishing Islamic law from the religion, that is Shariat, without any competent authority to enforce it. The Islamic faith was adopted as the moral framework, while the Muslim law supported by the state was seen as the basis for legal decisions. Students, the legal principles of European countries have dramatically impacted the interpretation of Muslim law by the judiciary. Consequently, contemporary Islamic nations have endeavored to maintain Islamic law with a modern interface. Countries like Turkey, Tunisia and Egypt are working to codify their laws to preserve the Shariat's intrinsic character. These laws are being formulated in the courts to meet the requirements of modern society. Now, we will proceed to discuss Islamic schools and their subdivisions, that is the branches of Islamic jurisprudence, the schools of Muslim law. Sunnis and Shias assert that Prophet Muhammad was the acknowledged leader of the Islamic Ummah. He held the ultimate control over the law and served as the principal administrator for the entire Muslim community. Following his demise, the primary concern was to ascertain his successor. The overwhelming majority of the Muslims advocated implementing an election to determine the successor. One side contended that the Prophet's exercise of ultimate leadership was a characteristic of an Islamic community. The ideal candidate for his successor should be able to influence Muslim community. Students, this section of a successor necessitated the trust and assurance of the populace, making the elections the sole viable approach. This segment of the Muslim community advocated for the use of elections as a means of determining the successor of the Prophet and his traditions. They relied on this tradition and subsequently held an election in which Abu Bakr, the father of Aisha Begum, was elected and became the first Khalifa. This group of Muslims, led by Abu Bakr, established the Sunni branch of Islam. I repeat, Sunni branch of Islam. They chose the moniker Ahle Sunnat wal Jamaat, which translates to the people of the tradition and assembly. They are commonly referred to as Sunnis. However, there was a minority of Muslims who did not adhere to the notion of election. This group prioritized the spiritual guidance provided by the Prophet over his administrative authority. Fatima, the daughter of Prophet, served as the representative for this marginalized community. They argue that the successor, in terms of the Prophet, should be a spiritual leader of the community just like the Prophet. They contended that this attribute is inherent in the essence of one's lineage. Thus, an individual who shares a blood relationship with Prophet Muhammad or belongs to his family should be considered the most qualified person to inherit his position. Students, the Fatima group rejected the election based on the idea of succession. As a result, Ali, who was Prophet's son-in-law and Fatima's husband, and also his cousin, was chosen as the first Imam by a group of Muslims who distanced themselves from the majority and formed a separate faction known as Shia, which means section. Therefore, it is evident that the division between Muslims into two sects, Shia and Sunni, originated from the disagreement among the Muslims on the method of selecting the successor of the Prophet. Students, consequently, these two fractions emerged as the primary schools of Muslim jurisprudence. Subsequently, the Sunni sect underwent more divisions, resulting in the emergence of many subgroups in the form of Hanafi, Maliki, Shafi'i, and Hanbali sects. Each part represents a unique school of law. Similar divisions can also be found among the Shia sects, such as Ithna Ashari, Imamiya, Ismailiya, and Zaidiya. Akbari and Usuli were further derived from Ithna Ashari sects, and Khoja and Bohra were derived from the Ismailiya sects. Students, now let's discuss the Sunni schools. The inaugural Sunni school is known as the Hanafi school. The school of Islamic jurisprudence is named after its founder Abu Hanifa and is widely recognized as the most prominent school of Muslim law. Abu Hanifa, a renowned scholar of his era, gained widespread recognition for his exceptional logical reasoning and technical legal thinking. Although he was offered the position of Qazi, he declined it because he did not want to be compelled to make the judgments that were against his conscience. Abu's primary contribution was his approach of not unquestioningly adopting every provision mentioned in the Quran as a law, but instead seeking to uncover the underlying principles within the text itself and making inferences based on analogical reasoning. Students, he favored making private judgments based on Quran backed by scientific conclusions rather than mindlessly relying on traditions. He believes that laws should be developed based on the society's evolving needs when no specific law is mentioned in the Quran. It can also be acquired through the unanimous determination of legal experts. He proposed that if law fails to achieve justice, justice equity be employed to interpret the law. Now we will discuss the Maliki school. Malik ibn Anas founded this sect of the believers in Medina. He was a renowned scholar and was considered as the foremost authority on the traditions. Imam Muhammad, a jurist known as Hanafi, was Malik's preferred student. The Maliki school acknowledges the customs of the companions and successors of the companions. Ideally, this school seeks to derive new rulings solely from their decisions. If this is not feasible, the opinions of Qiyas and Ijmas, I repeat, Qiyas and Ijmas may be considered. However, it is essential to note that this school only recognizes the authority of jurists who are residing in Medina. The scope of Ijma as a source of law should be limited according to the Maliki school of thought and subsequent scholars who have the authority to act as judges. Consequently, they were required to address the daily issues faced by the general population. Students, now let us discuss the Shafi'i school. Ash Shafi'i, the founder of this school, was again a renowned scholar of Islamic jurisprudence. He was a prominent figure among the followers of Maliki and had a close association with the Prophet. He established medical schools in Baghdad and Cairo and similarly emphasized the importance of financial gain. But his dependence on traditional practices was much more significant than the Maliks. He analyzes the decisions using legal reasoning and logic to establish well-balanced and organized regulation. Students, he believed there was no human problem that could not be resolved by Quran or the teachings of Prophet. These solutions can directly be obtained from these texts or analogous deductions. He maximized the utilization of Qiyas and successfully established it as a legal authority. He suggests that Qiyas should only be considered after analyzing the Quran, traditions and ijmas. Students, now we will discuss Hanbali school. The next school on the list is Hanbali school. The fourth and the most recent school within the Sunni branch was founded by Ibn Hanbal. He received instruction from multiple distinguished scholars. His distinguishing characteristics is his unwavering adherence to the tradition of Prophet. Therefore, it is stated that he was more of a traditionalist than a jurist. He heavily depended on tradition to the extent that other sources of law such as Ijma and Qiyas were disregarded. Consequently, there is no opportunity for individual assessments or human rationalization. Next, we have the Shia sect school. Students, this school is commonly called as the Ithna Ashari school. The majority of Shia practitioners are devout adherents of the Ithna Ashari school. It is said that there have been 12 Imams, starting with Ali, who have supernatural and spiritual powers. Anything originating from Imam is regarded as an absolute rule. There is a belief that the 12th Imam who went missing during childhood will eventually emerge. One notable attribute of Ithna Ashari school is that it is the only school in the Muslim world that acknowledges mutta, which refers to the temporary marriage. Next in line we have the Ismailiya school. According to their belief, there were only 7 Imams, with the 7th being the most important. They think that a lineage of covert individuals known as Imams, were consistently vigilant for an opportunity to exploit the vulnerabilities in the vast and the fragile dominion of Orthodox Islam stemming from their ancestors. It is a strong belief among Khojas and Boras that Imams were alive, but they have chosen to hide their presence. Now, let us discuss the Mutazila sect. The Mutazila developed as an independent faction of Islam in the 9th century AD. Ats al-Ghazal founded the school during the Mamun's reign. While they do not identify with either of the two established fractions, it is believed that they played a role in the community. Amir Ali noticed that a careful examination of Mutazila highlighted that they did not emphasize triple talaq. Divorce by talaq is not recognized in Mutazila. Students, now let us discuss the sources of Islamic law. The name Quran is derived from the Arabic word Qura and specifically denotes the reading. The Quran is considered of divine origin and is believed to have been revealed to the Prophet Muhammad for the sake of humanity. The Quran is the first and the primary source of Muslim law, both chronologically and in the terms of significance. Before the Quran, there was no Islamic civilization as it exists today. The first revelation, known as Wahi, was received by the Prophet in 609 AD. Subsequently, the revolutions persisted in providing sporadic prophets for the 3 years until 632 AD, when the Prophet ultimately passed away. During his lifetime, the Prophet intermittently conveyed the teachings of his followers, proclaiming them as divine revelations. The Quran is of divine origin. In Islam, it is widely held that the words and verses of the Quran, a holy book, are divinely authored by Almighty God rather than by any human being. The Quran serves as the primary and the foundational sources of law. It consists of verses, each verse referred to as an ayat. The Quran contains 6,237 verses and is organized into 114 chapters. Each section of the Quran is referred to as surah. The chapters of the Quran are organized thematically and each has distinct titles. The Quran encompasses elements of religion, law, and morality. If a specific interpretation has been assigned to a particular version of Quran by either Shia or Sunni authorities, the courts are not empowered to assign a different interpretation. Students, it is important to note that Quran does not encompass the entirety of Muslim personal law. The text mainly encompasses verses that pertain to the principles of life and religion. Specifically, there are approximately 200 verses that address legal matters, and out of those, roughly 80 verses pertain to personal law. Next source is Sunnah or Hadith. The next source refers to the traditions and teachings of the Prophet. In context of Muslim law, the Prophet referred to the guidance and teachings obtained from God. Any actions or decisions made by the Prophet without explicit reference to God are considered part of his traditions and serve as the secondary source of Muslim law. Traditions are the teachings and guidelines derived from the words of God as conveyed by the Prophet. The words of Prophet were seen as the ultimate source of authoritativeness, as it is thought that their utterances were divinely inspired in Islam. There are two types of revelations, namely Zahir and Batin. Zahir revelations are openly spoken and believed to be the direct words of God, communicated to the Prophet through an angel. The revelations mentioned before, which were part of the Quran, can be categorized as either explicit or implied. The Prophet directly stated explicit revolutions, whereas implied revolutions were inspired by God but expressed through the Prophet's words, batin. Next in the line is the essence of the Prophet's teachings and actions. All the statements made by the Prophet that were not contradicted when questions were considered authoritative and established a precedent. The tradition in Muslim law is derived from the Sunnat al-Qawl, which refers to the statements or actions of the Prophet Muhammad. Sunnatul Fail includes his behavior and his silence. Sunnatul Takrir in response to the questions posed to him for his judgment. Students, remaining silent can be interpreted as an agreement or endorsement of the principle of governance by law. Next in line for discussion, we have relator of the traditions. In other words, recounter provided testimony that they either heard the Prophet say something, witnessed the Prophet doing something, or observed the Prophet remaining silent. If this testimony was deemed trustworthy, it quickly became an established tradition within the community, effectively creating a new law. Subsequently, the writer was obligated to possess the necessary qualifications. To mention a few, individuals who met the following criteria were considered competent. He likely comprehended the necessity of acquiring the ability to retain information. He likely adheres to the Islamic faith. He must exhibit proper behavior. The companions as well as successors of the companions and the successors of the successors were acknowledged narrators. Now, coming to the conclusion of this discussion, the verses of the Quran address several aspects of legislation and have effectively abolished unpleasant and immoral practices such as child marriage, infant mortality, unrestricted polygamy, and gambling, among others. The Quran consists of the divine words of God. Hence, the Quran holds the highest authority in Muslim law. The discussion began by addressing various types of conditions, namely universally accepted traditions, followed by popular traditions, and finally isolated traditions. The next source of Muslim law, as discussed, is ijma, which refers to the unanimous decisions of jurists when the Quran and traditions do not provide a rule of law or a solution to the new problem. Ijma refers to a jury's consensus, opinion, or unanimous verdict in which knowledgeable individuals with expertise in law agree and share their collective viewpoint on a particular matter, specifically about Mujahid. Students, with this, we come to an end of today's lecture. Thank you very much for the patience listening. Have a good day.